If you're in the hemp business or buy on the internet, we've got 5 headline lawsuits with versions of the same outcome. Courts siding with state power while Congress sharpens the knife to rewrite what hemp even means. If you've been betting your business on the 2018 Farm Bill and preemption magic or a Commerce Clause Hail Mary, this is your wake-up call. Let's talk about what courts actually said, because the internet, as you know, is full of copium and wish casting. We're going to start in Virginia, which kicked off 2025 like a bang with Northern Virginia Hemp and Agriculture LLC versus, of course, the state of Virginia. The Fourth Circuit took one long look at SB 903, Virginia's total THC regime that sweeps in Delta 8, Delta 10, and friends, and said the quiet part out loud: the 2018 Farm Bill protects moving hemp across state lines, not your right to retail intoxicating hemp derivatives inside of a state. That's just not what it says. And so there was no preemption because of the text of the Farm Bill. No dormant Commerce Clause win because in-state and out-of-state actors had to comply with total THC levels as the law says. It's in the published appellate opinion. And that Virginia ruling just didn't stay in a vacuum. Lawyers immediately started dropping it into other cases as persuasive authority. Why? Because the 4th District isn't the whole country, but also it undercuts the industry's favorite argument that Congress mandated a national market for intoxicating hemp as long as it is Delta 9 THC compliant. The 4th Circuit made clear Congress allows states to be tougher. Translation: if your business model relies on federal law that says I can do it, but the text doesn't actually say that, courts will not build you a bridge out of THCA. Next, we go to Arkansas later this year, Biogen LLC versus Sarah Huckabee Sanders. She's the governor right now. The industry got an early TRO/PI, that's temporary restraining order, and preliminary injunction win, but the 8th Circuit reversed in June 2025 and greenlit Arkansas's Act 629, which criminalizes most psychoactive hemp products. The appellate panel walked straight through the statute and said the Farm Bill doesn't expressly preempt state restrictions because the federal transportation language isn't a universal permission slip for sales. And Arkansas's scheme, by the way, doesn't fatally conflict with any federal objective. It actually slipped in that provision regarding interstate commerce. And vagueness and equal protection, they didn't buy that either. The actual opinion, not a blog summary, the opinion expressly points out the Farm Bill when it starts off by stating the text itself that nothing in this subsection related to state-submitted plans preempts or limits any law of a state or Indian tribe that 1, regulates the production of hemp, and 2, is more stringent than this subchapter. The court goes on to explain that the preemption portion of the Farm Bill regarding interstate transport does not prevail as the law provided for its compliance. Moving to a different state, the Hemp Association of Louisiana and Cypress Hemp LLC sued, of course, Louisiana, and attacked its Act 752 with its 5 milligram THC caps per serving, age gates, gas station bans, total THC definition. The federal court let them amend, but it didn't hand them an injunction. Where are we now? The judge has already granted leave to amend their already amended complaint in July of 2025. And this is a district court and not the appeals court yet. Motions to dismiss and briefing will be live territory. The statute remains in effect because no TRO or preliminary injunction has been issued, because they have to bring back their Second Amendment complaint. That's what stalled litigation looks like. Expensive filings for TROs and PIs and 2 amended complaints. No relief down to your last bite of the complaint apple. But you have very real legal fees to lawyers that said you had a good claim. The theme repeats. Courts see a cooperative federalism structure where Congress told the USDA to work with states and explicitly let states be stricter. That's not fertile soil for conflict preemption, as the hemp community of Wyoming found out when they sued their state after it passed a law that excluded semisynthetic substances like Delta 8 from being hemp, which had already been defined by the Wyoming legislature as total THC in 2019. A federal judge later denied preliminary injunction relief in July 2024 and then dismissed the challenge in August of 2024. The appeal to the 10th Circuit is pending, but let's be real, it hasn't come yet, and every month that ticks by with no emergency relief is another month of the status quo. Wyoming's ban stands. Businesses adapt or die. Plaintiffs are bleeding while waiting for a ruling. The district orders are public, and industry press covered the dismissal. The dockets confirm the appeal posture. If the 10th Circuit wanted to send a lightning bolt message, we probably would have seen it by now. I mean, here we are, it's October 2025. Speaking of 2025, earlier in 2025, Tennessee dropped the hammer on hemp with HB 1376 becoming effective January 1st of 2026, September of this year. Cornbread hemp sued to stop it. That law forces hemp into the same three-tiered system that alcohol has used since Prohibition ended. Suppliers have to sell to in-state wholesalers. Wholesalers then sell to in-state retailers, and consumers can only buy face-to-face in Tennessee. No more direct-to-consumer, or DTC as they call it. No more supplier to the retailer deals. On top of that, the state flat-out bans health-related claims about hemp products. Doesn't matter if they are true. Doesn't matter if you slap on disclaimers. It's a total gag order. Cornbread is a Kentucky hemp company with millions of dollars worth of Tennessee customers. Their complaint is a three-pronged attack as follows. First, the Dormant Commerce Clause. They argue Tennessee can't discriminate against interstate commerce by forcing everything to flow through local warehouses and face-to-face shops. It looks like protectionism dressed up as consumer safety. Courts have struck down similar schemes before, like when Tennessee tried to protect funeral directors or residency rules for liquor licenses. And Tennessee already allows direct shipping of wine with age checks. So the "we need to keep hemp out of kids' hands" excuse rings a little hollow. That's probably their strongest claim and may get them at least a TRO or preliminary injunction, provided the definition of hemp does not change in Washington, D.C. this year. Second, they raise the First Amendment. They say the ban on health-related claims violates commercial speech rights. But when they say that, here's the rub. Commercial speech is protected only if it's about a lawful product and not misleading. But hemp companies have been muddying the waters for years by making wellness claims that's a lot like medical claims. And the FDA has sent numerous letters to many CBD or hemp companies that say that CBD or THC are not approved dietary supplements or drugs and can't be put into the food supply under the Food, Drug, and Cosmetic Act. Courts don't like total bans, of course, but Tennessee has a good argument that all health claims are inherently misleading because the FDA hasn't approved any of them. Cornbread may win a narrower ruling, but let's not kid ourselves. Judges aren't about to open the door to THC and CBD cures your insomnia infomercials. And last or third is substantive due process, SDP. This is literally a Hail Mary because of its judicial review level. They argue that the law is so arbitrary, it violates the 14th Amendment. The Sixth Circuit once struck down a Tennessee casket sales law on that basis, but courts are very reluctant to play the philosopher king when it comes to economic regulations. Like seriously, like 99% of the time, such challenges fail. So if the Dormant Commerce Clause doesn't carry the day, this won't either. On paper, Cornbread has some decent arguments. They've hired lawyers and are throwing constitutional spaghetti at the wall, hoping that some of it sticks. But zoom out. This lawsuit is happening at the same time the whole hemp hustle is hitting roadblocks state by state. Meanwhile, congressional action looms. The 2018 Farm Bill legalized hemp with one dividing line. It's all cannabis. But some has less than 0.3% Delta-9 THC, and that's hemp, and therefore not marijuana. That one line has created a multi-billion-dollar intoxicating hemp market, mostly Delta-8, THCA flower, other weird, strange hemp-derived, and of course, the THC beverages you see everywhere. Basically, it's marijuana sold under a different label. States hate it. Licensed cannabis operators hate it, and even Congress is hinting that they screwed up. Lawmakers didn't mean to create a parallel marijuana market. They meant to legalize rope and CBD lotion. The USDA, DEA, and FDA have been saying for years, fix this mess. This isn't hemp. And the fix on the table for the next farm bill is simple. Redefine hemp so it's not psychoactive cannabis. Everything else, sure, that could be hemp. But psychoactive cannabis, marijuana again. That's the big picture. Cornbread may notch a legal win in Tennessee. It may not, it's early on, and protect their shipping lane for another year or two. But if Congress redefines hemp, it won't matter. Their lawful product becomes an unlawful drug again, and all their constitutional arguments are just gone. Judges can't protect a business model that vanishes overnight by statute, and that may be one of the reasons why these lawsuits keep losing. There's at least 3 of them, and they aren't mysterious. First, there's the actual text. Courts read the Farm Bill's interstate clause as a trucking shield, not a retail sword. It protects the movement of compliant hemp across state lines, not your right to sell Delta 8 at every gas station in America. Congress wants to federally legalize retail hemp intoxicants. It would have said so. It didn't. And that's straight from the 4th and 8th circuits. Second, the structure. Congress built a cooperative federalism model. States submit hemp plans that can be more stringent. Translation, Washington invited states to tighten the screws on what hemp is. Courts see that as intentional, not accidental, and that torpedoes most preemption arguments. And third, the fallback doctrines favor the state. The Dormant Commerce Clause claims only win if the law is clearly discriminatory or imposes a clear lopsided burden against out-of-state actors. Even-handed THC caps applied to everyone usually survive. We'll see if the 3-tier regulation in Tennessee that is also uniformly applied as well will survive. And of course, SDP challenges substantive due process that hit rational basis review. Hint, you're going to lose that 99% of the time. If lawmakers can imagine any health reason, you lose. That's exactly what happened in Arkansas. And so here's the kicker. Courts cement state power. Congress is moving to rewrite the rules entirely. House appropriations have already slipped total THC language into must-pass spending bills, counting THCA and closing the intoxicant loophole. The Senate talk is similar. The Congressional Research Service spells it out. Both chambers are considering restrictions far beyond the 2018 Delta 9 only definition. And if they pass, preemption arguments don't just lose, they vanish. Motion to dismiss granted. And about Congress, it's not just the Farm Bill reauthorization. Multiple legislative vehicles are at play. The 2026 appropriations bills, agricultural riders with new hemp language. The proposals are explicit, and they redefine it to make sure that it's all THC and any semisynthetic and many other things. So if any of those hit before the end of the year, all these lawsuits are dead. And therefore, what's your strategy as a hemp company? Are you going to keep spending money on lawyers to litigate preemption in the Dormant Commerce Clause? No, that's last season's playbook. The appellate scoreboard already favors state deference. Unless you have like real smoking gun out-of-state discrimination or a speech ban that is extremely overbroad, your odds are not what the press releases claim or what your lawyers are telling you. If Congress rewrites hemp to total THC, the lights go out entirely. No, that's not hype. That's in the bill's text. Just read any one that's coming out of Washington, D.C. Therefore, optimized for survival, there's really only a couple of rational lanes. You can pivot to what the strictest state is going to say, like 3 milligram THC caps, 21 plus age gating, no cartoons in the packaging, real batch testing. Regulators like to reward businesses that act like adults. And then, of course, get political. If you want any intoxicating hemp lane federally, you need Congress to spell out potency threshold. Perhaps offer that in exchange for taxation. Courts can't invent that framework for you. Only statutes can. Write checks to lobbyists and reps instead of lawyers. One more reality check. Even a narrow First Amendment win in Tennessee won't reopen Virginia or Arkansas, and maybe soon Texas or Illinois, California. Distribution bans and chemistry-based caps stand on different pillars than speech. A single lawsuit won't create a national intoxicant market under a farm bill that Congress never intended. The federal bench has already told you that twice, loudly and in detail. So is this the hemp as we know it? No, I remember it being about industry and CBD back in 2018. It's the end of the loophole era. The Delta 8 gold rush is almost over. Courts don't do wishful statutory interpretation. And if Congress adopts total THC plus anti-conversion rules into semisynthetics, the federal floor will match the strictest states, not the loosest. That means fewer intoxicating SKUs, more compliance, and maybe no intoxicating SKUs at all. Here's what you're going to see from the hemp industry over the coming weeks and months until the feds set the policy for the next decade. Calls to the representatives begging for a framework that makes no changes at all, or at least preserves non-intoxicating hemp, but still with THC, so they can keep selling THC labeled as hemp in small doses. And then they'll set science-based age-gating rules if an intoxicant lane survives. And preemption only where it's necessary to stop whiplash from 50 conflicting state schemes. If you want that world, it won't come from injunctions. It'll come from legislation by lobbyists instead of lawyers. But I don't think the legislatures want hemp being marijuana after watching the policy game for years. It's just me. If you learned something here, don't forget to subscribe and help us get to over 100,000 subscribers so we can spread this information about the policy issues even further. And drop us a comment on which issues you want to see covered. They really help me come up with ideas for the next videos.